Good morning, everyone. My name is Suba Viswanathan. I'm here with my colleague John Ho. I'm a labor and employment lawyer here at Bond, Schoeneck King. I advise and represent employers in all aspects of labor and employment law, and part of what I do is representing employers in investigations conducted by the New York State and U.S. Departments of Labor, as well as in state and federal court proceedings involving alleged violations of the Fair Labor Standards Act and the New York labor laws. I'll let John go ahead and introduce himself.
Sure, and Sue and I are both in the labor group here at Bond, and I'm in New York City, and as you can see from the slide, Suba's in Syracuse, and since we do a lot of the same thing, I won't bore you with just repeating what Suba said, except to say that in what seems like a past life, I'm a former prosecutor with the United States Department of Labor, so as we go, if anyone has any questions about DOL process or audits, I'd be happy to try to share any relevant experiences I have while I was with the department. And good morning, everyone, as well.
So what we're going to do today is explain what the U.S. Department of Labor is proposing to do with the white-collar exemptions, and to help you think about what you need to do to prepare for the issuance of the final rule. We're planning to leave some time at the end to answer some questions, but please don't feel like you have to wait until the end to submit questions. You can go ahead and submit questions as they occur to you based on what we're talking about, and we'll address as many of them as we can at the end. We do apologize in advance if we can't get to your question. We have a lot of attendees today, and we're anticipating that many of you will have questions. But if we don't get to your question, please feel free to contact either me or John at any time after the webinar, and we can discuss your question.
So let's start with the proposed salary threshold. If anyone has actually taken a look at the proposals, they're actually online. If you suffer from insomnia, it's about 200 pages. The primary thrust of it is this, which is the Department of Labor is proposing an increase to the minimum salary threshold in order to be exempt under the white-collar exemptions. As I'm sure all of us are aware, currently under the FLSA, the threshold is $455 per week, which of course, as the slide shows, equates to an annual salary of $23,660 per year. As written, the proposals would significantly increase that amount to $970 per week, or an annual equivalent of $50,440 per year. And as Suba will talk about in a couple of slides, most states have counterparts that may mimic but may not be nearly identical to the FLSA, and New York is no exception to that. And for those of us with New York operations, the salary threshold is greater than the FLSA, and you see the numbers here. The annual minimum salary requirement is $34,125 per year, which is going up, and this is already passed, so this will be effective. The $35,100 annual salary will be effective December 31 on 2015. We do note that in New York there is no minimum salary threshold for professional exempt employees, which of course there is under the FLSA. So we have a little tag here for future New York increases, and I think what's troubling here is, and we can, we'll talk about, how these kinds of increases to the salary threshold will affect your bottom line, but New York likes to lead in this area, as many of us know. We have a higher minimum wage. The minimum wage is also going up at the end of the year, and so I think if history is any indication, if these proposals are implemented, it won't be surprising if shortly thereafter New York might even consider raising it again. If history is an indication, that seems to be a pattern. So right now we are looking at the primary goal is to increase the annual threshold to $50,440, and we're going to talk about some strategies to help control that fiscal cost. But just be aware that, again, New York may try to lead and increase that even further. So if we go to the next slide, another proposal is the highly compensated employee exception. And under this exemption, if an employee earns $100,000 per year, then under the FLSA, there's a very limited duties test they have to satisfy. The department is proposing to increase that amount to, as you can see here, $122,148 per year. Again, if this doesn't mean that once you earn that, you're automatically exempt, only that you have to satisfy a very limited duties test. There's no specific counterpart to the highly compensated exemption under the FLSA, except New York does adopt it, and New York has various wage orders that will cover your establishment depending on what industry you are in. If there's not a specific industry wage order like building services or hospitality that applies to you, you're most likely covered then by the miscellaneous wage order. So although we don't have express regulatory exemption, it does adopt this, so it will apply. So in the future, if this does pass and the employee is earning, over the 122, 148, then again, you will only have to pass a very limited duties test in order to be exempt. And then Suva's going to talk a little bit about the indexing.
Yeah, so the way the U.S. Department of Labor set up their proposed rule is, in order to prevent the new salary level from becoming outdated and to avoid having to revise the regulations again, the U.S. DOL is proposing to automatically update the salary level from year to year. And what they're doing is they're proposing two alternate methods for the automatic updating. And they're soliciting comments regarding which method would be the most appropriate basis for the annual updates. The first method is based on using the 40th percentile of weekly earnings for full-time salaried workers. And this is the method that the Department of Labor used to come up with their projected salary level of $970 per week, because that's what they're anticipating will be the 40th percentile of weekly earnings for full-time salaried workers by the first quarter of 2016, when the final rule is ultimately issued. The second method that the Department of Labor is considering to automatically update the salary level is based on changes in the Consumer Price Index for all urban consumers, which is one of the indicators that's used for measuring inflation. But regardless of the method that is going to be in the final rule, the Department of Labor is proposing to publish the new salary level in the Federal Register and on the Wage and Hour Division's website at least 60 days before the updated salary level would become effective. So theoretically, employers would have, once the new salary level gets issued in the Federal Register and on the website, employers would theoretically have 60 days to prepare for the next salary increase and determine who's going to continue to be eligible for the exemption. The Department of Labor believes that the two methods will result in similar increases to the salary level from year to year, but again, they're looking for comments to determine which method to put in the final rule. The Department of Labor hasn't proposed any changes to any of the duties tests for the white-collar exemptions, but in its notice of proposed rulemaking, which as John said is 295 pages in total, they're soliciting comments on whether changes to the duties tests are necessary. Specifically, they're asking for comments on whether employees should be required to spend a minimum amount of time performing work that's their primary duty in order to qualify for one of the exemptions, and if so, what that minimum should be. As some of you might know, if you have California operations, California currently has a law that says at least 50% of an employee's time has to be spent on exempt duties in order to be considered exempt under California law. And the Department of Labor is seeking comments on whether that sort of California bright line rule should be incorporated into the federal regulations, and if 50% is the correct number, or if some other percentage should be used to be incorporated into the final rule. Right now, in the federal rules, there's no minimum amount of time that an employee has to spend performing exempt duties in order to be considered exempt. An employee just has to do exempt work as the primary duty, which includes consideration of a number of factors, such as the relative importance of the exempt work, freedom from direct supervision, as well as the amount of time spent on the exempt work. And actually, the current regulations specifically say that nothing requires an employee to spend more than 50% of his or her time on exempt duties, and employees who spend less than 50% of their time on exempt duties might still be considered exempt if the other factors, such as relative importance of the work, freedom from supervision, support the application of the exemption. So the U.S. Department of Labor is also looking for comments regarding whether additional occupations should be added to the regulations as examples of positions that would generally fall within the exemptions. So at this point, it's not clear whether the final rule is going to include any revisions to the duties tests. If it does, maybe business groups have an additional argument as to why the final rule is invalid, because perhaps there's an argument that the Administrative Procedure Act wasn't followed by issuing a proposed rule and then allowing people to comment upon it, and then issuing the final rule because there wasn't sufficient notice. Theoretically, there wouldn't have been sufficient notice of what the changes to the duties tests were. So we'll have to wait and see to see whether the Department of Labor blindsides us with some changes to the duties tests.
And Subi, can I add a couple of comments here?
Yep, go ahead.
Sure. If you believe the department and workers' rights groups and plaintiffs' lawyers, they would suggest to you that, look, if we increase the salary threshold, the goal is it's greater clarity for employers. That if we do this, you're going to know who's exempt and who's not exempt with a much clearer picture, and therefore litigation is going to go down. And this is why this is a wonderful idea for everybody. Look, if these are passed, we'll see if that happens or not. I'm skeptical because, first of all, as Suba just noted, nothing right now in the proposed regulations are going to affect the duties test, and that's where all the litigation really is. So if the duties tests themselves aren't changed, you have to wonder why is it going to be that the litigation is going to go down. And in 2004, when the regulations were last revised, that was also one of the primary reasons why the department increased the salary threshold and made modifications even to the duties tests to clarify for employers, at least allegedly, in the hopes that litigation would go down. Well, since 2004 till today, flash forward to 2015, we all know that litigation has exploded under the FLSA, where the ABA now says that out of all employment class actions combined, the FLSA outweighs them all. So again, if that's the purpose, if there aren't changes to the duty test, I'm not sure that the regulations will necessarily have that effect. But I think that's just worth mentioning.
The Department of Labor is also seeking comments on whether to allow non-discretionary bonuses and incentive payments to be used to satisfy a portion of the salary requirement, and if so, whether that amount that can be counted should be capped at a particular percentage of the minimum salary requirement. Currently, you can't count non-discretionary bonuses as part of the salary. I'll let John talk about the potential timeline.
Sure. So on June 30th, the notice of proposed rulemaking came out, and then they were published on July 6th. Under the current timeline, there's a 60-day comment period, which tentatively ends September 4th. After that, DOL will take a look at all the comments, make decisions whether they're relevant or they want to make changes based on those comments. And there's no hard line for when the final rules will be issued or what they will look like based on the comments. But certainly, I think most people are forecasting that it's not going to happen until 2016, and maybe even later. A couple of things here. If the salary proposal, even if you have comments to the duties test, whether they're working or not working for you, I would strongly encourage you to submit comments, and you can do that online. The Department of Labor has a website where that can be done. There's already been a significant amount of comments asking the department to push out the September 4th deadline. If I was a betting man, I would guess probably that the September 4th deadline will be pushed out, but again, if 2004 is any indication, the Department of Labor, when they published the revised regulations 2004, did go out of its way to really reference a lot of these comments by either law firms or industry groups or even single employers. And so the department clearly is looking at them. Whether they actually accept them or not into the final proposals, we'll see. But again, they are looking at them, so I would encourage you, if you've got concerns about these, to go in and offer comments. So the next slide, we're talking about, again, as I just mentioned, there are been comments to extend the 60-day period. And of course, not surprisingly, many Republicans have talked about, they're aware this is coming down the pipeline and talking about, attacking them. And there are certain legal ways that you can attack this rulemaking process. And as Suba mentioned with the duties test, particularly, we think if they actually come up with proposals that that become effective, that change the duties test, to us that would clearly circumvent the public comment period by not actually putting affirmative thoughts out there, but just asking for opinions and then making that regulation. So hopefully that won't happen, but if it does, that can be attacked that way. Again, there's a Congressional Review Act, which essentially says, look, the Department of Labor doesn't really have the authority to do this. This should be an act of Congress. Many Republicans are, stating that if these regulations are published, then they're going to attack that way. But as we all know, they can say it. Whether they do it is a little bit less common, but that's also out there. So we're not even sure when they're going to be implemented. It's obviously something we're all concerned about, but even if they are passed, it may not be the end of the story. So the biggest impact, well, obviously we saw what the new salary threshold is, the $50,440. So if you're within, if you have an organization where particularly your frontline supervisors are earning less of that, then obviously this is going to be a big concern to you. We're going to talk about some strategies on how to deal with that. Some of the comments, if you look at, criticize the department because, there are differences. There are geographic differences. The South and Midwest generally have lower salaries than maybe the Northeast, and obviously a uniform federal law that attaches to everybody without considering those geographic regions, is questionable. I mean, even within New York, Suba is in our Syracuse office, and I'm in New York City. We have clients that span New York, and to be blunt, we see that differences in upstate and downstate, and this might, clearly have maybe a greater impact on our clients upstate. There are certain industries, if you're in the hospitality, tourism, retail, and nonprofits that, generally speaking, will have lower, fiscal reserves and obviously lower salaries. So these are the industries, particularly, that if you're in, you're paying very close attention, I think, to this kind of, significant increase in number. One thing we would note that the regulations currently, the salary basis test and the salary threshold does not apply to doctors, lawyers, and teachers and outside sales employees, and nothing in the proposed regulations are changing that. And there are a couple of economic groups that are actually, that I found out are doing studies about this, and I think they're going to be posting their studies in the public comment period that really exemplifies how hard different regions of the country are going to be hit by this increase. And again, that's just one way that the proposed regulations of the salary threshold can be attacked, and I think certainly will be. And then Suba's going to talk about some risk management issues.
Yep. So that brings us to the steps that employers can take at this point to manage the risk even before the final rule is issued. The first step, and we would recommend this, really on a regular basis, even when there isn't a proposed rule in effect, perhaps on an annual or biannual basis, do a self-audit. Figure out where the biggest areas of risk are. Figure out whether there are certain positions that you think might be misclassified. And one thing to consider is who should actually conduct that self-audit. Should it be someone internal to your organization, such as your human resources office, or someone else within your organization, or should it be outside counsel? One advantage to having your outside counsel conduct a self-audit is that the results of the audit and the advice that's given to you by outside counsel will be protected by the attorney-client privilege. So if you do have a Department of Labor investigation or You do get litigation. Plaintiffs file a class action against you. The results of that audit would not be disclosable either to the Department of Labor or in discovery in the litigation. If you do the audit internally, the results of the audit and any internal communications will likely not be shielded from discovery. So if there are particular problems that are identified and for some reason those problems aren't corrected, that could potentially be an issue in terms of a determination of a willful violation. You should also consider variances in state laws as part of your self-audit. John mentioned earlier that New York has had for a while higher salary level thresholds than the Fair Labor Standards Act has had. So that's one thing to consider. If you have operations in multiple states, make sure you're looking at what those salary thresholds are and whether there's any nuances in terms of the duties test. As we mentioned earlier, California has a bright line rule in place that says 50% of your time has to be spent on exempt duties. So when you're doing your self-audit, if you've got a multi-state operation, you need to look at those state nuances and make sure that you're in compliance with those variations in state laws as well. So what should your self-audit consist of? Obviously, because of the proposed rule, one thing all employers will have to do is evaluate what positions are currently classified as exempt that will no longer meet the salary level requirement for the exemption. So they'll have to be reclassified as non-exempt. Or obviously, we're going to talk about some strategies later, but perhaps if it's close to the threshold, maybe you consider raising the salary instead of converting to non-exempt and paying overtime. But it wouldn't hurt, even though the focus of the proposed rule is on the salary level, it wouldn't hurt to concurrently look at your duties as well, just to make sure that you're not exposing yourself to potential liability by continuing to classify certain positions as exempt that might not meet one of the duties tests for the white-collar exemptions. So your review of the duties should include, certainly looking at job descriptions, looking at performance evaluations, talking to the individuals who supervise those positions to make sure that the job descriptions are accurate and that the employees in those positions are actually doing what's in the job description. And if they're not, you might want to consider revising the job description. But it's important to make sure that over time that your duties requirements are still being met for the individuals who are classified as exempt. Certainly you should look at collective bargaining agreements to determine how those agreements will impact on the exemptions analysis. One question that we get a lot is whether the salary level is prorated for part-time exempt employees. So if an exempt employee meets the duties test for one of the exemptions, but they're actually working only 20 hours a week, is the salary level prorated? And the answer to that is no. If an employee doesn't meet the new $970 salary level requirement, the employee is going to be non-exempt even if the person is working part-time and earning $500 a week. So, I mean, as a practical matter, it probably doesn't matter because the employee probably wouldn't be working overtime anyway. So if the person is classified as non-exempt, you're probably not going to have that overtime liability. But the person would be a non-exempt employee, and you would have to make sure that the person tracks their time and that you're complying with all other aspects of the law for non-exempt employees. Just as it is for all employment decisions, documentation is critical. If you make the decision to reclassify an employee from exempt to non-exempt, make sure you're keeping a record of the reasons for the decision, as well as any communications that were made to the employee about the decision. Make sure you're keeping that in the employee's personnel file.
Super. Can I just talk a little bit about the timing of the audit? Obviously we just talked about we're not sure when these regulations are going to go final, and obviously even in what form, but we suspect it will probably be 2016. But I think one of the benefits of doing this audit now, even though we don't have that deadline, is look, if you do your internal audit and you discover you've got some classification issues, and even if it's not a salary level, somebody's making $60,000 a year, but the bookkeeper is really doing non-exempt duties, and so we've got a concern. Maybe it's a social worker. There's some of these job titles that there's been some litigation over. The good thing is with everybody that's in this space knows about these proposals. People are talking about it. So when the regulations all rolled out, it really becomes, and this may not be the best word for it, but good cover to make that transition strategy. Because in 2004, this also happened as well. Some people made the transition from exempt to non-exempt, even though they had nothing to do substantively with the changes. They were issues with the duties test usually. It did provide that reasonable basis where the employee's not necessarily going to say, well, if I'm non-exempt now, what was I a year ago or 2 years ago? What about my overtime pay? Which of course is usually $1 million question after you get the audits back and you determine that maybe I've got some issues. Is how do you transition that without obviously getting sued over it? So I think that's really an important thing to remember, of doing the audit now, getting your results, so when the regulations are implemented in whatever form, regardless of whether they're going to, if that's the reason for the misclassification or not, it's an easy thing to explain. And if people look around and they go on the website, they're going to say, yeah, there are changes, and that makes sense to me. So I think that's one thing to really that would justify doing an audit sooner rather than later.
Yes, so the second risk management step is to roll out any changes. And as John mentioned, the timing is really a strategy question. Whether you, if you identify issues, do you reclassify now, even before the final rule gets issued, or do you wait until the final rule gets issued and kind of use that as the reason for the final rule being issued? And one reason to wait, as John said, is that it might reduce the potential claims for back pay if you wait until the final rule is issued and then you reclassify. Potentially employees are going to be less inclined to go to the Department of Labor because it's going to be very highly publicized that there is this rule out there that changes the exemptions. So one thing is, let's say you identify some problems in one of your duties tests, and that person doesn't meet the new salary level. Again, that's a pretty good reason to wait. Or you could, in anticipation of the final rule, go ahead and make the change and use that as the reason, the salary level as the reason why you're making the change, as opposed to the duties, because that won't tip any employees off that potentially they might have been misclassified going backward. It's also important when you reclassify an employee from exempt to non-exempt to determine exactly what the communication to the employee is going to be, and make sure that all supervisors stick to that script. A lot of times when you make the reclassification decision, the communication is done by human resources. But that employee isn't going to limit their questions just to human resources. They're going to go to their direct supervisor and ask questions about, why was I reclassified? Why do I now have to keep a timesheet? Why do I have to punch a clock now? And it's important for the direct supervisors and really anybody else in the supervisory chain to be able to know what the message is that they need to deliver to the employees when questions are raised. That way everyone's delivering a consistent message, and you're going to be less likely to have Department of Labor complaints if everyone's delivering that consistent message. One possibility that could arise with more frequency now, and John mentioned the geographic differences. I imagine some of you have operations in more than one state. Sometimes you might have employees doing the exact same position, but based on geographical differences or perhaps based on seniority, you might have employees in the exact same position doing the exact same duties. Some of them are going to be paid less than the new salary level. Some of them are going to be paid more than the new salary level. What you do in that circumstance is really a strategy issue. it's perfectly okay. It's permissible to have some employees in that classification be exempt and some employees in that classification be non-exempt. If you decide that you want to treat all of the employees in that classification the same way, then I think you need to consider how you can potentially control overtime, because you're going to need to convert them to non-exempt. And if you can control the overtime, then maybe it's okay to switch them all to non-exempt. But this is a problem that I think is going to arise more frequently now that the salary level has been increased than it has arisen in the past. Make sure that your supervisors are also well-trained in terms of record keeping, as well as compliance with any other state law requirements. You can have all of the policies and procedures in the world, but if the people who are responsible for implementing those policies and procedures aren't well-trained, they aren't going to help you. So make sure that your supervisors know what records need to be maintained. For example, in New York, employees are required to get at least a 30-minute meal period for shifts in excess of 6 hours. Technically, the New York State Department of Labor says that this applies to both exempt and non-exempt employees, but I've never actually seen an enforcement proceeding against an employer for not giving exempt employees a 30-minute meal period. But make sure that supervisors are aware that they can't just make unilateral decisions to let people work through meal periods. Even if it's an exchange for leaving a half hour early, supervisors just can't make those unilateral decisions to allow people to work through their meal periods, and they need to make sure that they're tracking, keeping some sort of record of when people are beginning and ending their meal period. One common method of controlling overtime work is to restrict employees from working outside of their normal work hours without written authorization from their supervisor, which is perfectly permissible. So if the employee performs work outside of normal work hours in violation of the policy, you'll obviously still have to pay the employee if you're aware that the work was done, but you can discipline the employee for not complying with your policy. And that's potentially one way. If you do have to reclassify people from exempt to non-exempt based on this final rule, that's one potential way of controlling the costs associated with the overtime work. Be really aware, though, of supervisors who kind of quietly encourage their employees to do overtime work but discourage their employees from actually reporting it. Make sure that all supervisors are aware that if employees are working overtime, that it has to be reflected on their timesheets. I'll turn it back over to John to talk about exempt status.
Yep, as Subha mentioned, obviously one thing that employers can do, particularly if they're close to the line, so to speak, is just increase the salary to meet the minimum. And to this, the Department of Labor in the proposals state that the direct cost to employers, they estimate to be about $250 million per year. Now, again, I think it's a little disingenuous because although these proposals can result in increased labor costs, they don't necessarily have to. Obviously, this situation where you increase will result in that, and if you're close to the line, it may make sense just to do that. Obviously, Subha just talked about the part-time employee issues where it doesn't matter if you want to keep them as exempt, there's no prorating. Some of the side effects of raising the salary, could be pay compression, which of course is the concept that, the gap between pay is very small between the highest paid and the lower paid employee, and this isn't really necessarily a legal issue, but it could be a labor relations one. We could probably, spend the whole webinar talking about pay compression, but just be aware that you may have to deal with some of these pay compression questions that can lead to, morale issues. Obviously we want to, Subha talked about the annual indexing and how automatic increases have been considered by the department. If those go into effect, we certainly want to make sure that, we're budgeting for those in the future if they're going to be automatic. Subha talked about during the audit process, obviously reviewing primary duties, even though the duties tests aren't necessarily going to be affected because there are ways to gain control and make sure that everybody's properly classified, whether it's salary basis, minimum salary threshold or duties test, where again, it's probably 95% of the litigation focuses on the duties test. And we talked about some differences already in between New York with greater salary levels, greater minimum wage. The mealtime provision that Suba just talked about is a creature of New York statute, and there are some duties differences even between the white-collar exemptions, where under the executive exemption, the New York says has a discretionary, executive employees have to regularly exercise discretion, which doesn't necessarily, well, it doesn't actually, is not a formal requirement under the FLSA. So again, an audit that's done properly should be aware of all these kinds of state and federal differences, and these are things that we want to look at if we're going to continue with the exempt status and by just increasing the salary threshold. Another issue, of course, is transitioning that employee to non-exempt, and of course this is going to be a cost management issue. And as I said before, the department estimates $250 million, but the reality is nothing in the FLSA tells an employer how much employees have to make, except for, of course, minimum wage. So I think what a lot of employers are going to try to do is back into a rate, appreciating that, okay, this employee probably works about 50 hours a week, so let me get an hourly rate plus an overtime rate where, it's going to come approximately to their annual salary anyway. I mean, I think this has a lot of, probably fiscal appeal. Suba talked about the controlling overtime piece, and in some ways, sadly, this strategy very well, you're never going to probably have an exact hit. It may not be their exact annual salary, but in many ways, if the overtime is not available, employees are going to be actually earning less, right? Because if they're only working 45 hours a week and they're budgeted at 15, the takeaway is, the gross pay is going to be less for that week, and the flip side may be true as well. But I suspect if you are transitioning and trying to find an hourly rate plus overtime, you're probably going to guess, you probably want to budget on, the overtime being on the higher side, right? Because generally speaking, you prefer to have, budget costs come in, lower than greater. So that's one issue that I don't think the department really is genuine about, because they suggest that, oh, this is going to, result in all this money, where it doesn't necessarily have to. And again, the controlling overtime piece is going to be, the largest factor in what that hourly rate is going to look like. If we turn to the next slide, again, non-exempt employees, you can pay hourly. It's probably the simplest way in some respects, but you can also pay non-exempt employees through a salary. Of course, they have to get the overtime premium. There's piece rates, there are commissions, and these are all ways that compensation can be designed. The issue, of course, is depending on whatever method you pick, the law says, okay, well, this is how you calculate the overtime rate if you pay on this basis. And we're not with this. It's outside the scope of this webinar to discuss those calculation rates, but just be aware you're not necessarily stuck with an hourly rate. You have flexibility. Just make sure that whatever compensation plan or structure you use, that you are calculating overtime properly under the regulations for that particular methodology. We have labor relations in here because when even before these regulations were proposed, we've had clients do audits and say we've misclassified and you want to move them to non-exempt status, and people often get upset, right? They may make more, they may make less, but people will have in mind, okay, I'm a salaried person, which means I'm important to the organization, I'm a white-collar person, and it results in some labor relation issues that you should be aware is common and have a strategy to deal with that. And obviously, with the script should talk to the employee, but look, these are this is a law that's been around since the 1930s. They're changing. These are compliance issues. This has nothing to do with your worth at the organization. But again, these are your employee benefits may be affected, which again I don't think the department really has considered, because certain organizations for their exempt employees or their managers or their supervisors may have better fringe benefit plans that now these employees may be disqualified from. So those are all considerations that you need to think about in trying to get your arms around the labor relations piece, which can be difficult. So then we can move to the next slide and let Suba talk about the salary.
Yep. So let's assume you want to keep you're converting people from exempt to non-exempt, but you want to keep them paid on a salary basis. How do you go about computing their overtime rate based on their salary? And the key question is, what exactly is how many hours is their salary intended to cover? So if the salary is intended to cover a 40-hour work week, you would essentially take the weekly salary, let's assume it's $700 a week, divide it by 40 hours, and you would get your regular rate of $17.50 per hour. And then your overtime would be paid at time and a half. So you'd pay $26.25 per hour for any hours over 40. Now, you can use what's called a fluctuating work week method of paying the employee as well, as long as there is a clearly communicated agreement in effect before the work is performed, where the employee clearly understands that the salary is intended to compensate for all hours worked in the week, regardless of whether it's less than 40, at 40, or over 40. And if that method is being used, then what you can do is take the weekly salary divided by the total number of hours worked in the work week. So let's assume that it's still the $700 weekly salary. The person works 50 hours in a particular week, and you've agreed in advance that the person's going to be paid on a fluctuating work week basis. Then you would take that $700 divided by 50. You would get a regular rate of $14 per hour. And since that $14 an hour has already been paid for all hours worked in the work week as straight time, what you would owe is an extra half time of $7 an hour for the extra 10 hours of work. Again, you do need to have a clearly communicated agreement in effect prior to the work being performed in order to use that fluctuating work week method. And make sure all of you who have operations in New York are aware of the Labor Law Section 195 requirement to provide a wage notice. If you're going to convert people from exempt to non-exempt, it's obviously going to change their pay structure. It's potentially going to affect their overtime rate. But they didn't have an overtime rate before because they were exempt. So you will need to provide a new Section 195 notice whenever you convert an employee from exempt to non-exempt. If the goal is to convert an employee from exempt to non-exempt, but create an hourly wage for that employee, so basically convert the employee from salary to hourly, you need to figure out what your goal is. If the goal is to essentially try to keep the person at a similar level of compensation that they earned when they were exempt, what you would want to do is try to figure out your best estimate of how many overtime hours the person might work in a given year, and try to back into an hourly rate so that the straight time plus overtime for the overtime hours worked will approximately equal what the person was being paid in salary before they were reclassified. And again, make sure you communicate this clearly. When you're switching people from exempt to non-exempt, especially if you're creating an hourly rate, as John said, it's going to create potentially some discontent on the part of employees. So make sure that you're clearly communicating to them why you're doing it, how you came up with your hourly rate, and potentially how they could benefit from the fact that they're getting time and a half for hours worked over 40, to the extent that you can make them somewhat happy with the transition. It's less likely that you're going to have to defend a Department of Labor complaint.
So, this is a recurring theme in the last couple of slides, because obviously the fiscal issue of converting someone from exempt to non-exempt is really about the overtime, right? So how and every organization and every position is going to be different, but this is what we need to give some thought to, right? Operationally, what can we do? What can our organization do for this particular position to control the overtime? And here, if the person is right now exempt, their chances are in the modern age that we live in, he or she is carrying around an iPhone, a BlackBerry if they still make those, or whatever handheld device, and they have access to email and remote access maybe from home, and those are There's been a lot of litigation, as everyone could probably imagine. It's a growing area of the law, and how do you track that time? Make sure that you have a mechanism, an accurate record-keeping system in place where if that non-exempt employee now still has those obligations and has to be accessible, is continuing to do those things, that we can track that time. And you can rely on reporting mechanisms for some good cases that the burden is ultimately on the employer to have the records, but self-reporting is okay. And as Suba talked about before, we have to make sure that our policies are written where we can control that, right? Whether it's prior supervisory approval, all the things that we're obviously currently doing with our non-exempt employees. And this might very well require distribution of hours. It's going to be a scheduling issue in some events, reassigning job duties and particular jobs to help control those hours, all things we want to think about. When the FLSA was passed in the 30s, and when Roosevelt was president and the Great Depression was upon us, one of the primary goals was to create two jobs. So instead of, it was really a penalty for employers to allow employees to work, and that may be another issue where now you're going to have to split the job up in maybe two part-time jobs to help control the overtime piece, and particularly, again, that was really one of the primary purposes of the FLSA back when it was passed, many, many years ago. So these are all things that obviously you need to think about. What's a good answer for one organization and one position may not be for another, but that is really going to be the key on the fiscal piece. For administrative issues. And again, these are all things that we're doing right now for non-exempt employees, but you're going to have the same record-keeping obligations for them, and there's no, again, magic way to keep track of hours for non-exempt employees, no single form, but the objective and the requirement is now we have to keep accurate daily records, whereas exempt employees, we don't have many of these requirements. Suba talked about the New York meal period law. I will just say on this issue, if you have an automatic deduction policy, if they're not per se illegal, but the Department of Labor, the New York State Department of Labor very favors automatic meal period. I've never had an audit where the department has found some violation of it. So if you do have that, just be very cautious and just make sure that you have a mechanism set up where if they do work through a meal period in whole or in part, that there's a way you could the employee can report that, and hopefully you can show that, look, in the last 3 months, these 5 employees worked through the meal periods and they were paid, which helps demonstrate that that policy, that enforcement is working to track that time. Pre and post shift work, a lot of litigation in this area, things that if you're like Tyson Foods for the chicken manufacturing, has been sued a dozen times for their employees donning and doffing certain kinds of safety equipment. So you have that kinds of situations, you want to take a look at it to make sure that we're capturing all compensable time. If it's even just before the start of their regular shift. Suba mentioned the Wage Theft Prevention Act notices here in New York. Those all going to need to be modified. And obviously offer letters, handbooks, job descriptions, and anything that that's going to describe the duties are going to need to be, we're going to need to take a look at and want to take a look at to make sure that all the revisions are done appropriately.
Here's just some useful websites that you can consult for more information. The first is our firm's labor and employment blog, which we update fairly regularly. Second is obviously the Department of Labor's website. The third is the website for the Wage and Hour Defense Institute. I know John is an active member of that organization. And if you pull up the homepage, you'll see a picture of his smiling face right there on the homepage. Do you want to talk any more, John, about what the Wage and Hour Defense Institute does?
I would just say that if you have operations in other states, obviously Bond's blog covers many federal laws, and for our states, we primarily focus on New York. If you do have operations in other states, that's a very helpful tool because we have lawyers that specialize in this area spread across the entire country. So that's a very good resource for if you're across a number of states.
Yep, and these last two websites are just links to the Department of Labor's frequently asked questions and the fact sheet on the proposed rule. All right, let's try to take some questions. All right, the first question is, are nonprofits or small businesses subject to the FLSA salary thresholds and these new changes? So it's the definition of coverage under the Fair Labor Standards Act is fairly expansive. It's really any organization that's engaged in interstate commerce. So that's really kind of the threshold question, is whether the organization is engaged in interstate commerce for purposes of the Fair Labor Standards Act. And even if they're very small businesses, if, for instance, there are significant amount of goods or products that are sold interstate, it's very likely that's going to subject the organization to FLSA coverage. Anything you want to add to that, John?
Yeah, just on the nonprofits, there's no specific exclusion for nonprofits, but again, as Suba had talked about, it's an interstate commerce issue. So certain nonprofits, and this we could talk about this probably for a couple of hours, the legal test on whether a nonprofit is engaged in that or not. But suffice to say, there's no specific exemption, but some may not be if you go through the test. But if the nonprofit competes with other for-profit businesses as a general rule in some ways, like an animal shelter that may sell flea collars or something, that could very well trigger coverage where there may not have been. But generally, I would say it's going to cover most. But if you're in a nonprofit that does a very specific, non-competitive, non-entrepreneurial kind of business, you may want to take a look at the coverage. But even putting that aside, you would still be covered under the New York labor law. So even if you can escape the FLSA, you're going to be, private sector employers certainly are going to be covered regardless of size or for-profit or non-profit status under the New York labor law.
Second question is, do both the salary and the duties requirements need to be met in order to be exempt? Or if the duties requirements are met but the salary requirements are not, can the person still be exempt? And yes, both need to be met. There are certain types of exemptions that do not have a salary requirement, such as the outside sales exemption. Teachers do not have a salary requirement. As John mentioned earlier, doctors, lawyers, there's no salary requirement for those types of occupations. But for general, executive, administrative, and professional employees that fall outside of those, teacher, doctor, lawyer classifications, the employee will need to meet both the salaries and the duties requirement in order to be exempt.
Right, and and just to follow up on that, what we've been talking about today is which is generally known as the white-collar exemptions, as Suba just mentioned, the professional, executive, administrative, outside sales. This is what the proposed regulations talk about. But as many of you may be aware, the FLSA has many other kinds of exemptions, very particular ones that affects agricultural employees, one that exempts commercial drivers of commercial motor vehicles that go interstate. So those are not those very specific ones we're not talking about today. And as Suba just talked about, some of those may not have these requirements. So, but for these, certainly, as Suba said, is right on. Both of them have to apply.
Third question: if salaried employees become reclassified as non-exempt and they typically start their workday early, can the employer say that they will not begin their paid day until normal start time?
Right. And so that goes to that pre and post shift slide that we had. You can absolutely set a work schedule for employees and say, look, your work schedule is going to be 9 to 5 and you've got the half-hour meal period. You track the hours, but what you cannot do is turn a blind eye to compensable work, right? So my assistant's hours are 9:30 to 6, and if I come in and if it's 6:15 and I see her out there and I say, good night, Bettina, and I don't say anything, she's 15 minutes past her shift, that's going to be compensable time. I have knowledge of it, right? And that knowledge can be imputed to me through computer records, login and log off times. So although it is absolutely perfectly appropriate and you should set regular work hours, the problem lies in enforcement of that, right? They cannot do any work before they start their shift, before their shift starts, they cannot do any work after. And a lot of times, employers will allow employees to come in and punch in and sort of wait around until the start of their shift. That is a very bad practice. A, your records are no longer accurate because they're not actually working, and the FLSA and the New York labor law require us to have accurate records. So, the better thing is look, if you want employees to come in early, sort of chit-chat, have some coffee, that's fine. Make sure your policy is very clear. They are to perform absolutely no work until the start of their regular shift. And you need to train supervisors that if they see that, it's going to be a discipline issue. And, the funny thing about this sometimes is, sometimes you're speaking with your best employees, the ones that really just want to do the job, right? It's not necessarily about the few minutes of time here, the few minutes of time there. They're staying after because they want, they want everything to be done right, and that's great. But that's compensable time. So if you don't want to pay for it, you've got to, it doesn't have to be, something, severe, but certainly some progressive discipline, a verbal warning, and then a written warning, because when the Department of Labor comes in, they're going to want to see that in order to demonstrate to them that, those scheduling and those policies are not just in writing, but being enforced.
All right, next question is regarding the 195 salary notice, isn't New York changing that and no longer requiring it in the near future? The legislature did eliminate the annual notice requirement, so you no longer have to provide the annual notice between January 1st and February 1st each year. But the requirement to provide the notice to new hires and the requirement to provide the notice when the pay has changed or the conditions of pay have changed, that is still in effect. Next question is, can we have non-exempt employees paid a salary and not fill out a timesheet unless they work over 40 hours? For non-exempt employees, you really should be tracking on a weekly basis all hours worked, even if the person does not work overtime. I have seen employers have a practice where they only track hours if there's a deviation from the normal schedule. So people are normally scheduled to work, let's say 8:30 to 5 with a half-an-hour meal period each day. So they're paid for 8 hours per day. And then they only fill out a timesheet or fill out some sort of deviation report if they work less than that 40-hour schedule or more than that 40-hour schedule. My recommendation, I can't say, maybe John, you can speak to what the U.S. Department of Labor's opinion is of that. My recommendation is to have people track their hours regardless of whether it's a deviation from their normal schedule.
Yeah, absolutely. And I think, the reading of the record-keeping requirements is that they have to. There's no exception for people paid on a salary, even though that salary is intended to compensate them from a certain amount. And I could just tell you from a litigation standpoint, it's, as Suba suggested, it's a bad practice. It puts you in a defensive spot. And again, there's no exceptions in the regs. So you really need to, unfortunately, track on a daily basis, and obviously the overtime only kicks in on a weekly over 40. But the record-keeping requirements are pretty restrictive in that sense that they're onerous.
All right, we have time for one more question. We've got about a minute left. So the last question is it advisable to begin, prior to final regulation, reclassifying staff who are currently exempt to non-exempt based on the anticipated salary increase? I think it's a matter of strategy and timing. If you have people that you know are not going to meet, that they don't currently meet the new salary threshold, and you know they're not going to meet the new salary threshold, and you think from now until the time the final rule is being implemented that it's not going to impose significant additional costs on you to reclassify them as non-exempt, I don't see a reason why you have to wait. But again, if you think reclassifying them at this point is going to create overtime obligations for you and potential extra costs, it probably makes sense to wait until the final rule is actually issued. That way you have absolute certainty of what the final rule is. Who knows, the Department of Labor might surprise us and actually reduce the the salary threshold that they proposed at this point. So I think it's a matter of strategy and timing. If you don't think it's going to add additional costs, perhaps you can go ahead and do it now. I still think it's probably more advisable to wait until the final rule is issued. John, do you want to add anything to that?
Yeah, the thing I would, if your transition is based solely on the increase to the salary, then I'm with Sue 100%. I think it's better to wait because, as I suggested before, there are talks about Republicans are potentially going to attack it on a legal level, and it may not actually go through, although I think everyone thinks that it certainly will. But if you're changing because of because you have duties test issues, you've done an analysis and you're looking and say, wait a second, I've got people misclassified, that becomes a much trickier issue. And then that becomes much more factually specific. How many people are we talking about? Right? Is this a high turnover? There are a lot of other considerations. What is the total cost? So again, if it's strictly on the increase of the proposed salary level, I think waiting is a much better idea. But if it's a duties issue, then I think speaking with counsel and getting your arms around those factors is going to be very case by case specific.
Thank you. That's all the time that we have. I appreciate you attending our webinar. And again, if for some reason we didn't get to one of your questions, or if you have anything else you want to talk about, John and I are available.
Thanks, everyone.